Welcome, learners. Today on the deep dive, we're tackling a really important topic, something that affects so many people looking to study abroad.
That's right. We're diving into the F visa system for international students here in the United States.
Exactly. So if you're thinking about studying in the US, or maybe you're already here navigating the F visa, well, this deep dive is definitely for you.
Uh-huh.
Our goal today is simple. Cut through all the complexity, pull out the key insights from everything we've looked into, and really help you understand F visas, from applying to staying legal and what happens next.
And it's so vital because, the F visa, it's not just a stamp. It's a specific legal status. It has a very clear purpose and a whole set of rules attached.
Right.
Understanding those rules, it's absolutely paramount for things to go smoothly while you're studying here.
Okay, so let's unpack that. What exactly is an F visa? And you mentioned types.
Yeah, basically F visas are non-immigrant visas. They're for people coming here for academic study or maybe language training. The main one, the one most people get, is the F-1 visa. That's for full-time academic students. That's our big focus today.
Gotcha. F1.
Then you've got the F-2 visa. This is for dependents, so the spouse and any unmarried kids under 21 of the F-1 student.
Ah, the family members.
Exactly. But it's crucial for F-2s to know
Yeah.
they generally can't take paid work. Minor children, though, they can go to public school, K through 12.
Okay. Important restriction there. Any others?
There's also the F-3 visa. It's less common. It's for what they call border commuters from Mexico or Canada.
So they live there but study here.
Precisely. They cross the border to attend school, could be part-time or full-time. One key difference from F-1 is they typically can't work on campus, though certain practical training might be possible later on.
Interesting. So for the main one, the F1, what are the basic requirements someone needs to meet?
Right, the core eligibility for F-1. Well, first, you need to be accepted into an academic or language program.
Makes sense.
And the school itself.
Yeah.
It has to be approved by SEVP. That's the Student Exchange Visitor Program. We'll mention SEVP a lot.
SEVP approved. Okay.
You also have to be a full-time student. You need to show you're proficient in English or you're enrolled in courses to get there. You absolutely have to prove you have enough money to cover tuition and living costs. And critically, you need to demonstrate your intent to leave the U.S. after you finish your studies. It's a non-immigrant visa, after all.
Right, the temporary intent. So it's clear these visas are tied directly to study. How do the schools themselves fit into this picture? They sound pretty important.
Oh, they're absolutely pivotal. Like I said, the school must be SEVP certified. They go through a process using Form I-17 to prove they meet government standards for hosting international students.
Okay.
And once they're certified, each school has at least one designated school official, or DSO.
DSO. That sounds official.
It is. Think of the DSO as your main point person of the school's international office. They manage your record in SEVIS. That's the Student and Exchange Visitor Information System.
Another key acronym, SEVIS.
Definitely. The DSO issues your Form I-20, which is maybe the most critical document you'll have as an F-1 student. And any changes program dates, course load, taking a break, you have to tell your DSO so they can update SEVIS. They're your lifeline, really.
Okay, so the DSO is your go-to person at the school. Now, let's get practical. You're admitted, you know who your DSO is. How do you actually get the F1 status? Walk us through those steps.
Right, it starts with that Form I-20. The school issues this after they admit you. It lays out your program details, name, start date, end date, and crucially, how you'll pay for everything. They can actually mail this physical document to you overseas.
So you need that I-20 in hand first.
Yes, and before you apply for the visa itself, you need to pay the SEVIS fee. That's done using Form I-901. It's a one-time fee tied to that specific SEVIS record.
Okay, I-20, then SEVIS fee. Then what?
Well, it depends where you are. If you're outside the U.S., you'll apply for the F-1 visa stamp at a U.S. embassy or consulate in your home country.
The visa interview.
Exactly. And you can't schedule that interview too early, no more than 120 days before the program start date listed on your I-20.
Good tip.
Then, when you arrive at the U.S. border, the port of entry, an officer checks your visa, your I-20 makes sure everything's in order. They'll then issue you a Form I-94.
I-94, and that has...
There will likely have DS marked on it.
DS, what's that stand for?
Duration of status. This is a really, really important concept. It means your legal status isn't tied to a specific end date on your visa stamp. It's valid for as long as you're maintaining your status as a student according to the rules.
Okay, so your status depends on following the rules, not just a date.
Got it. What if someone's already in the U.S. on, say, a tourist visa?
Good question. If you're inside the U.S. in a different valid status, you might be able to apply to change your status to F-1. You do this by filing Form I-539 with USCIS.
Is it that faster? Usually not. It can actually take quite a while, often 3 to 6 months, sometimes longer, and there can be complications. For example, if you entered on a B visa, a visitor visa, it really helps if it was marked prospective student. Otherwise, immigration might question if you intended to study all along when you said you were just visiting.
Tricky. Okay, what about changing schools?
If you transfer from one SEVP certified school to another, the process is usually smoother. You generally don't need a new SEVIS fee, and you don't file that I-539. You might even be able to travel and re-enter using the valid F-1 visa stamp from your old school, as long as your SEVIS record is properly transferred.
And that final step upon arrival.
Absolutely crucial. You must report to your school's international office, to your DSO, as soon as you arrive. They need to validate your arrival in SEVIS to officially activate your F-1 status. Don't skip this.
Okay, so you're in, you reported, your status is active, now that whole duration of status thing kicks in. What does maintaining F-1 status actually involve day to day? What are the absolute must-dos?
Right, this is where your responsibility really lies. That DS means you stay legal as long as you follow the rules. Plus, you get a 60-day grace period after you finish your program requirements.
60 days to, what, pack up?
Pretty much. Prepare for departure, or perhaps apply to change to another status if eligible. But you can't study or work during that grace period.
Okay, so the rules for maintaining status.
First and foremost, maintain a full course load. What that means varies a bit, but usually it's 12 or more credit hours per semester for undergrads, or maybe 18 plus clock hours a week for language programs.
What if you can't? Like your last semester or you get sick?
There are exceptions. You can sometimes get approved for reduced course load, RCL. Common reasons are being in your final term, having a documented medical condition, or maybe some initial academic difficulties. But, and this is critical, you must get authorization from your DSO in advance. You can't just drop classes and hope it's okay.
Get permission first. Got it. What else?
Keep your SEVIS record accurate. This goes back to the DSO. Any change if your program end date needs extending. If you change majors, if you move from wide, you need to tell your DSO right away, usually within 10 days, so they can update SEVIS.
Okay, stay in touch with the DSO. What about travel?
Right, travel and re-entry. Always make sure your passport is valid for at least 6 months beyond the date you plan to re-enter the U.S. That's a common mistake people make.
6 months validity, check.
You'll generally need a valid F-1 visa stamp in your passport to re-enter, unless you qualify for automatic revalidation.
What's that?
That's a rule allowing re-entry from short trips less than 30 days to Canada, Mexico, or some adjacent islands. Even if your visa stamp expired, as long as your I-20 and passport are valid and you didn't apply for a new visa while out.
Okay. But otherwise, need a valid visa.
And the I-20? Yes, your I-20 needs a recent travel signature from your DSO on page 2. Recent usually means signed within the last 12 months if you're actively enrolled, or within the last 6 months if you're on OPT after graduation. That signature confirms to border officials that you're still in good standing.
Okay, keep that I-20 signature updated. Anything else on maintaining status?
Yes, leaves of absence or withdrawing. If you need to take a break for more than just a normal school vacation, you need to talk to your DSO. If you take an authorized leave, your SEVIS record might be terminated and you typically have 15 days to leave the U.S.
And coming back.
If the break is less than 5 months, your DSO might be able to reactivate your same SEVIS record. But if you're outside the U.S. for more than 5 consecutive months, for reasons other than authorized study abroad, your F-1 status is generally considered automatically deactivated. You'd likely need a whole new I-20 and potentially a new F-1 visa to return.
Wow, okay, so being outside the U.S. too long is a big issue. This really underscores how vital that DSO relationship is.
Absolutely. They were your #1 resource.
Now let's talk about something many students are keen on, working. But the rules here seem incredibly strict, right? What are the key things to know, and what happens if you mess up?
This is definitely an area for caution. The rules are strict, and violations can have serious consequences. Let's break it down.
Please.
First, on-campus employment. This is generally allowed incident to status, meaning you don't usually need special permission beyond just being a valid F-1 student.
Okay, that sounds straightforward.
But there are limits. You can only work up to 20 hours per week while school is in session. During official school breaks, like summer or winter vacation, you can work full-time, meaning up to 40 hours.
20 hours during term time, and what counts as on campus?
It means work performed on the school's premises, usually paid directly by the school, or it could be for a commercial firm on campus that provides direct services to students, like the campus bookstore or cafeteria.
Ah, so not just any job physically on campus.
Exactly. Working for, say, a construction company, building a new lab on campus. That generally would not qualify as on-campus employment for F-1 purposes because they aren't providing direct student services. It's best to double-check with your DSO if the job isn't paid directly by the school.
Good clarification. Okay, what about working off campus?
Off-campus employment always requires specific authorization. It's never just automatically allowed. There are a few main types.
Okay.
First is curricular practical training, or CPT. This is work, often an internship, that is directly related to your major and considered an integral part of your curriculum.
So it has to be part of your study program?
Precisely. And critically, your DSO must authorize CPT before you start working. The authorization is noted directly on your I-20. You cannot start working until you have that authorized I-20.
Before work starts. Got it.
And here's a very important point about CPT. If you use 12 months or more of full-time CPT, you lose your eligibility for OPT after graduation.
Oh, wow. So using full-time CPT means no OPT.
Generally, yes. It's a trade-off you need to be aware of. Part-time CPT doesn't affect OPT eligibility.
Okay, that's a huge strategic consideration. What's OPT then?
Optional practical training, or OPT. This is also work related to your major, but is not necessarily required by your curriculum. Think of it as practical experience after, or sometimes during, your studies.
The post-graduation work period people talk about.
That's usually what they mean, yes. Post-completion OPT. Your DSO recommends OPT, but the actual authorization comes from USCIS, U.S. Citizenship and Immigration Services. They issue an employment authorization document, or EED card.
So it's a separate application to the government.
Correct. And you absolutely cannot start working until you have the EAD card in hand and the start date on the card has arrived. Applying too early or too late can cause denial. There are specific filing windows, usually starting 90 days before program completion and ending 60 days after. And you must file within 30 days of your DSO recommending OPT in SEVIS.
Lots of deadlines there. How long does OPT last?
Standard OPT is for 12 months. During post-completion OPT, you have to work at least 20 hours per week in a job related to your major, and you can't accrue more than 90 days of unemployment total.
90 days unemployment limit. Okay. Is that it for OPT?
Well, there's a very valuable extension for some fields, the STEM OPT extension. If your degree is in a qualifying science, technology, engineering, or math field, and your employer meets certain requirements, you can apply for a 24-month extension beyond the initial 12 months.
Wow, so potentially 3 years of work authorization.
For STEM grads, yes.
Oh.
There's also a category for severe economic hardship, but that requires proving unforeseen circumstances and getting USCIS approval for off-campus work. It's less common.
Okay. Now the scary part. What happens if you violate these employment rules? You mentioned consequences.
Yes, and this is where students really need to pay attention because the type of violation matters immensely. First, remember that 60-day grace period after finishing your studies.
The departure prep time?
Absolutely no work or study is allowed then. Doing either is a status violation.
Okay, no work in the grace period.
Now let's say you make a mistake, like working 22 hours on campus one week instead of 20, or maybe taking that questionable on-campus job with a construction crew. This is often considered a simple F-1 employment violation. It does mean you've fallen out of lawful F-1 status.
Out of status? That sounds bad.
It is, but it might be fixable. You generally have to stop the unauthorized work immediately. Then you can often apply for reinstatement with USCIS, usually with help from your DSO. Reinstatement basically asks immigration to overlook the violation and put you back into valid status, provided it wasn't egregious and you meet certain conditions, like applying within 5 months.
Okay, so reinstatement is like a possible fix for some mistakes.
Some mistakes, but then there's unauthorized or illegal employment. This means working completely without permission, working under the table, taking an off-campus job without any CPT or OPT authorization at all.
Right, the really forbidden stuff.
Exactly. And for this type of violation, reinstatement is generally not an option. It's considered a much more serious breach.
No fix. What happens then?
This is where it gets really serious. Engaging in unauthorized employment means you start accruing unlawful presence. If you accrue more than 180 days of unlawful presence and then leave the U.S., you could face a 3-year bar to re-entry. If you accrue 1 year or more, it's a 10-year bar.
3 or 10 years banned from the U.S. just for a work violation.
For that specific type of unauthorized work violation, yes. It can completely derail your future U.S. plans, whether for further study, work, or even just visiting. It's incredibly important to understand this distinction. Don't work without clear, documented authorization. Ever.
That distinction is absolutely critical. Wow, it really paints a picture of how structured this all is. Thinking bigger picture, has the system always been this, well, detailed? How did we get here?
That's a great question. It definitely hasn't always been this way. The F-visa system has evolved quite a bit, often reacting to major world events.
Like what?
Well, there was increased scrutiny after the 1993 World Trade Center bombing. But the really big changes came after 9/11.
Right, I can imagine.
Particularly since one of the 9/11 hijackers had entered on a student visa, although he reportedly didn't attend classes. That event was a major catalyst of creating the SEVIS system, which became mandatory in 2003.
Ah, so SEVIS came out of 9/11 security concerns.
Largely, yes. It created a centralized electronic way to track students from the moment they get their I-20 until they finish their program or leave. Before SEVIS, tracking was much more fragmented, often paper-based. Post 9/11 also saw rules tighten around trying to study while on a B visitor visa, making the F or M visa pretty much the only route for formal academic or vocational programs.
So SEVIS was a huge shift. Any more recent changes?
Well, the COVID-19 pandemic certainly shook things up temporarily. There were modifications allowing more online study than usually permitted for F-1 students to maintain status. Those rules have been adjusted back and forth since then.
Right, the online class waivers.
And a really interesting current challenge involves college athletes and NIL, name, image, and likeness.
Oh yeah, letting student athletes earn money from endorsements and things.
Exactly. But F-1 visa rules generally prohibit that kind of income generation, as the visa's purpose is study, not professional work or business. So international student athletes are often in a bind, unable to capitalize on NIL opportunities like their U.S. counterparts or even international students with green cards.
Wow, I never thought about that angle. So it creates an inequality there.
It really does, especially in sports with many international players, like soccer or tennis. It's a complex issue right now with ongoing debate about how or if it can be resolved within current visa regulations.
Fascinating how these external changes constantly impact the visa rules. Now, you mentioned M and J visas earlier. Can you just quickly recap the main differences so people don't confuse them with the F-1?
Sure. The M visa is for vocational students, think technical schools, cooking schools, non-academic programs.
Not university degrees.
Right. They also use SEVP schools and get an I-20 and have M1 student and M2 dependent statuses. But key differences. M1s generally can't work on campus. Extensions usually require filing a formal application, Form I-539, with USCIS, not just getting a new I-20 from the school, and their practical training options are much more limited and only available after finishing the program.
Okay, M is for vocational, more restrictions. What about J?
The J visa is for exchange visitors. This covers a wide range of people, students, scholars, researchers, au pairs, interns.
A broader category.
Yes. Similarities to F-1 include SEVP oversight, J-1 participant, and J-2 dependent status, usually allowed on-campus employment, and getting DS on their I-94.
But the differences?
Key differences. J-1 programs require a sponsor, could be a university, government agency, private organization, and are overseen by the Department of State, not just Homeland Security. The document is a DS 2019, not an I-20, and a big one. Many J-1 programs come with a 2-year home residence requirement.
Meaning they have to go back home for 2 years?
Yes. After their program ends, they might need to reside in their home country for 2 years before being eligible for certain other U.S. visas, like immigrant visas or HL work visas. Waivers are sometimes possible, but it's a significant requirement. Also, their practical training is called academic training, and their grace period after the program is only 30 days, not 60.
30 days versus 60. Okay, good distinctions to know. One last area that often causes confusion, taxes. What do F-1 students need to know about U.S. taxes?
Yes, taxes. It's definitely something F-1 students need to handle correctly. The short answer is yes, you generally need to file something with the IRS.
Even if you didn't work?
Potentially, yes. The key concept is your residency status for tax purposes, which is different from your immigration status. There's something called the substantial presence test to determine tax residency. But, and this is important, F-1 students are typically exempt from counting days toward that test for their first 5 calendar years in the U.S.
5 years. So for the first 5 years,
you can usually file taxes as a non-resident alien. This often means different forms and different rules than U.S. residents.
Okay, non-resident for the first 5 years, typically. What about income?
If you have authorized wages from on-campus work, CPT, OPT, that income is taxable. However, as a non-resident alien, Those wages are often exempt from Social Security and Medicare taxes, which could be a nice saving.
Good to know. What about scholarships?
Scholarships or grants that cover tuition and fees are usually not taxable. But if a scholarship gives you money directly for living expenses, room and board, travel, that portion is generally considered taxable income.
Okay, direct money might be taxed. Anything else?
Yes, a crucial form, Form 8843. All F-1 and F-2 visa holders physically present in the U.S. must file this form every year. They are considered a non-resident alien for tax purposes, even if they had zero income and don't need to file a regular tax return like a 1040 NR.
Form 8843, even with no income, when is that due?
If you don't have to file a regular tax return, it's typically due by June 15th of the following year. It's basically just stating you are an exempt individual under the substantial presence test. Also, check for tax treaties between the U.S. and your home country. They can sometimes reduce your tax burden. So, if we tie all these threads together, the rules, the history, the different visa types, taxes, the big takeaway for F visa holders really is vigilance, proactivity. Your status isn't guaranteed by a date. It's guaranteed by your continuous compliance.
Right. It's an ongoing responsibility.
Exactly. Staying informed, staying in touch with your DSO, understanding the rules. That's how you navigate this successfully.
So let's bring this home for everyone listening. Based on everything we've discussed today, what are the absolute crucial steps you need to take to maintain your F visa status and, frankly, avoid serious problems like deportation?
Okay, the essential checklist.
First, as we heard, always maintain that full course load. Don't drop below it unless you have that specific advance approval for a reduced course load directly from your DSO. Get it in writing or noted on your I-20.
Absolutely critical. Don't guess. Ask first.
Second, employment rules are not suggestions. Understand them inside and out. On-campus work. Stick to the 20-hour limit during semesters. Any off-campus work needs prior authorization CPT for internships tied to your curriculum, OPT, with that EAD card from USCIS for other practical training.
And remember that huge distinction we talked about.
Yes. A simple mistake, like working 21 hours on campus, might be fixable with reinstatement if you stop immediately and work with your DSO. But engaging in unauthorized work, working under the table, no permission at all, that can lead to losing your status permanently and facing those harsh reentry bars. Just don't do it.
It's simply not worth the risk.
Third, your DSO is your best friend in this process. Use them. They are your official guide. Talk to them immediately, ideally within 10 days, about any changes. Moving address, changing majors, needing a program extension, questions about work, taking a leave, changes for your F2 dependents. Keep them informed.
Communication is key. Don't wait until there's a problem.
Fourth, keep your documents valid and handy. Your passport needs to be valid for at least 6 months beyond your intended re-entry date, always. And for international travel, get that travel signature on your I-20 updated by your DSO regularly, annually while enrolled, every 6 months while on OPT.
Simple steps, but easy to forget.
And finally, that 60-day grace period after you complete your program requirements, it's for wrapping up and leaving or maybe changing status if eligible. It is absolutely not for working or taking classes, period.
That's the bottom line.
Your success here isn't just about getting good grades. It's about carefully managing your immigration status, too. Being informed, being proactive, asking questions. That's how you ensure a smooth journey.
Well said.
All the best, and we will meet again with another important matter in the next meeting.